So yes, the topic of my subject today is towards new legal approaches for animal welfare rights. Now, before delving deeper into the topic, I will first take you back into your memory and ask if you remember what you did on Sunday, the 1st of August 2021. So I think not many of you know or remember what you did. Well, I will tell you what I was doing. It had to do something with the Olympic Games, and in fact I have two passions. One is animal and law, and the other one is sports. And that Sunday there was a special day for us Belgian people, because there are many Belgians that know exactly what they were doing that particular Sunday. And why is that? Well, Nina de Waal obtained a gold medal in gymnastics. And now it was just part of our history that everyone exactly knows what they were doing on that particular moment. And actually what I was doing, normally I always watch the Olympic Games here at home on the television. I don't want to miss a thing, but I had an appointment with a friend of mine in Brussels. So I was actually lunching at the time Nina de Waal obtained her gold medal, but I was watching her on my cell phone. And why I was in Brussels? Well, there was a Banksy meeting, a Banksy exhibition. And yeah, you might know Banksy is a famous street artist. This is one of his more famous works. This is his more recent work on the Brexit. And in my view, of course, you know, art is always full of ambiguity, but he can also be seen as some kind of an animal advocate. You have his works, this one and also the one with the monkeys. And my favorite one is the Monkey Parliament. So, and this brings us then again to the topic of today. Will great primates ever run the world? So that's a question I will not yet answer now, but we will come back to it at the very end of the presentation. So here you can see a legal poster of my PhD, and it's actually also disappointing to see 4 years of blood, sweat and tears summarized in one A4 page, but yet it's also good to have a concise overview of what my PhD entails. And indeed, the presentation of today will correspond to my PhD, as I will elaborate on later. So speaking of an overview, this is an overview of the presentation of today, where we will mainly focus on the third part and less on the scope and methodology and so on. So I will use a part of the legal poster to dissect and to use it as a guideline during the presentation. So I highlighted 3 works of the title towards new legal instruments for animal welfare. As you might have noticed, these are different from the current title. Why is that? Because now seeing things backwards, I would have done some things others, or at least name it otherwise. Well, first of all, instrument might be a bit too narrow, so I would broaden it up towards approaches, which is in fact also what I explore in part 3 of my PhD dissertation, the sustainable development approach. So for the first disclaimer is instrument is in fact more than just instrument. That's one. Then secondly, animal welfare. Well, actually, I also examine animal rights avenues in my PhD as well. So you should, or I would readjust it to animal welfare rights with welfare between brackets. And the framework I've used during my PhD is that of Saskia Stuckey and the theory of legal animal rights. So on the concept of animal rights, we will drill down into a bit later. And finally, new, again, a disclaimer here, what's new, what's not new. Is a constitutional provision new? You can say that there already exist countries with such provisions, so to what extent can it be seen as new? That's true, but what I mean is, to give an example, Article 13 of the Treaty of the Functioning of the European Union, which is the Animal Welfare Integration Clause that requires that in the EU policy, animal welfare is taken into account in several policies such as agriculture and so on. What is not the aim, or what was not the aim of my PhD, is to do research to the impact, for instance, to Article 13, which is an existing article, although it might be very valuable, such research. This was not the intention. The intention was to look after new instruments, new approaches, rather than existing provisions and measuring their impact. But again, yeah, it should be nuanced, as we will see later on. But to clarify, Article 13 was not within the scope of this PhD dissertation, but I published on that topic in Dutch journal articles, but not on in my PhD in general. So this comes now consolidated in this new title, the title of today, towards new legal approaches, which may also comprehend instruments, but it's more broad, for animal brackets welfare rights. So here a clarification. Now, on this slide, you can see the actual table of content of my PhD. So first, an introductory frame of reference, then 3 main parts, and of course, some concluding remarks. Now, at the Ghent University, we have 2 possibilities of formats of submitting a PhD. At the one hand, you can choose for a classic PhD, which is a book, a classic book. But on the other hand, you can also submit several journal articles, but then you have certain conditions to check. For instance, they should have a general theme. You should have at least 3 articles published in a renowned journal of your field, and so on. And that is also the format of my PhD. So especially because the topic is more international, as in Belgium, we currently almost have animal law is almost non-existent. So that's why I choose to have such a PhD on journal articles. This has also the advantage that during your PhD, you already receive feedback. You can also have already impact because it's published right then on the moment and not a year after your research is done, and so on. So here's some general insights on the structure and so on. So the starting point is in fact the introductory part, where I delve deeper into the state of the art. And what I revealed from the state of the art is then used to build on for the other part. So for instance, the state of the art regarding the international level is that there is currently no animal welfare instrument, be it soft law, be it hard law, available. So that was one gap that I intended to mitigate in this in my PhD. Another one that was specifically for Belgium is that we currently don't have a constitutional provision. And at the time I started my PhD, it was very topical. There were discussions whether we would introduce it, yes or no. So with those findings, with the state of the art, I used it to find new legal approach, new legal instruments, and so on. Now, I did not just focus on a particular level, but the idea was to combine it. So there is research on the national level, the regional level, and the international level, combined with insights from human rights law, environmental law, and constitutional law. So it's the intersection between all those viewpoints that I will also discuss. So here then the three main parts. Part one is national animal constitutionalism. Part two is a European animal rights revolution. And part three is a sustainable development and animal welfare, international partners in crime. So part one is national animal constitutionalism, and you can dissect two important words. First, national, so it's on a national level, and secondly, constitutionalism, which indeed corresponds to constitutions. Now, as I mentioned earlier, the discussion on should we enter an animal provision in the Belgian constitution was very topical at the start of my PhD. And fun fact, it is in fact today still very topical. I recently received an invitation of the Belgian Senate to give advice as there are new proposals at the beginning, submitted at the beginning of this year, the 22nd of January. So it still is very topical. And what I did was I examined a constitutional provision of a country that already had such a provision to compare it with the Belgian context. Now, as you can see, the first case study is Germany. So why Germany? Because of course there are other countries as well, but the aim was to have also a member state of the EU. So Switzerland, for example, or Brazil would not fit in that idea. Secondly, compared to, for instance, Austria and Luxembourg, who also have such a provision, they are more recent. And Germany already inserted its provision in 2002, which consequently you have much more case law to examine and to measure the impact. And maybe also the most important reason is that in one of the proposals to adjust the Belgian constitution referred to the German proposal. So the idea of the submitters was to create a similar provision as was the case in Germany. And what I did was see what was exactly the impact, or what did this German provision do, and how should we create a similar situation in Belgium. Now, of course, regarding the limit time, I will not go in depth of all details, but I chose some subject to elaborate on more than others. Now, first, what I will do is elaborate on a state objective, because the provision, the particular provision in Germany on animals is a state objective. And in the orange framework, you can see the 4 theoretical functions that a state objective, at least in theory, should fulfill. So what I did was then look into the case law, also legal doctrine and so on, and see if indeed the case law corresponds to these theoretical functions of what a state objective should do in practice and also in theory. So you see that the results are very favorable. You have like almost 4 pluses, which means that indeed what Germany aimed to do also happens. Now, maybe a few words of what I mean with those sentences in the Orange framework. So first of all, a state objective should have impact when it is reiterated, for instance, in legislative and executive considerations. To give an example, if you have like an executive branch with a commission, an ethical commission that need to decide if a particular animal experiment is allowed, yes or no, when this commission refers to the particular state objective, we can say that, well, at least they took it into account. Of course, this is very straightforward, but it's just to give an example. Secondly, a standstill effect means that the current level of animal protection may not decrease. So it's some safety mechanism. And we see clearly in the case law of the German Constitutional Court that they expressly attribute this function to the state objective. Thirdly, the interpretation heuristic. Well, with regard to open norms, for instance, in the Tierschutzgesetz, but also in the Belgian Animal Welfare Act, we have such a word as unnecessarily, what is unnecessary, and then also the judges or the court uses the constitutional provision to give content to such concepts or terms. And finally, and also most importantly, is that it can be a basis for limiting fundamental rights. This function is very important and was also a deficit before that Article 20A was incorporated in the German Constitution. So what is the constitutional German system? Well, judges can only balance rights if they are both constitutional. So what happened is that, for instance, you have artistic freedom, which was incorporated in the German Constitution, and then you had some rights in the General Animal Welfare Act, and the judges always give priority to the artistic freedom because the Tierschutzgesetz is in a hierarchy lower than the Constitution. And with including an animal welfare state objective, that was no longer a case. So it did have a very important impact with regard to being a basis for limiting fundamental rights. But as I will highlight later on, the fact that it might be a basis does not mean that it will always prevail animal welfare. No, it's just a guarantee that it's been taken into account and taking in this balancing exercise. But before it was excluding in the first place. So it was in fact a non-balancing at all. Oh. So yet we see some improvements, some developments with introducing the state objective, and especially at that time, which is 2002, And now Belgium is considering to include it or not, and we are 2023. But at that time it might be progressive, but we see that one of the critics before they actually included, because there were already discussions in 1997, but they were lobbying from the farmer side and the industry and so on, because one of the objections was that it would harm farmers and it would harm the industry and so on. But on that side, we see that on the structural level, you have some case-by-case results that, for instance, with regard to freedom of occupation, also with regard to artistic freedom, which I mentioned earlier, and also the freedom of teaching, it did have a strong impact. But on a structural level, we cannot say that the state objective will impact factory farming or animal experiments and so on. At least not how it is structured in Germany. Now, secondly, what I did was look into the existing Belgian proposals and then also compare it to the German situation and so on. So what is the situation? Well, also in Belgium, the idea was to incorporate an animal welfare state objective. So I did the same exercise. What are the theoretical functions of a perfect state objective, and would a Belgian state objective also comply to it? Of course, we do not have an animal welfare state objective, but we do have one other state objective currently in our constitution, and that is one of sustainable development. So I scrutinized the case law concerning our sustainable state objective, and what I identified is that none of the functions actually correspond to what a state objective in theory should have as an impact. So that's very important, because the initiators, you should know that they do not have always a legal background, but they have the intention to create a situation which is similar to Germany. They expressly mention it in their preparations and so on. But what they do not know is that the title of a state objective can be different than its real content. So, of course, in Germany, you would have the state objective, and in Belgium as well, but you can also see that our flags are very similar, but that does not mean we are the same. And that's exactly what is misleading with the name of a state objective, because it would not have the same impact as it did have in Germany. Now, why is that? It's very technical now, but it's because of our Belgian constitutional system. And it means in the Belgian Constitutional Court can only review acts which are enshrined in Title II of the Constitution. It's named the Belgians and their rights. And you should know that Article 7, the Sustainable Development State Objective, the same article in which they also want to add animal welfare, has its own title, Title I bis, and is in fact excluded from the reviewing scope of the Constitutional Court. So many of the functions that did apply, for instance, the basis for limiting fundamental rights, would not happen in Belgium. Now, how can we create the situation in Germany in Belgium? Well, that's to use an article which is situated in this Title II of the Belgian Constitution, and that it's Article 23. It's already also the protection of a healthy environment, which we then would add animals into it. But that's only to create more or less the same situation potentially as in Germany. But of course, do we want the same situation, or do we want it to be more progressive? And that's why I also explored 2 new avenues. First of all, Route 66, which we would understand animal welfare as more classic fundamental rights. The advantage here is that you have a more, instead of just a vertical effect from citizen to the state, you should also have a horizontal effect. You should think of the climate cases, and the Shell case, for instance, was a citizen against a company and so on. So that would be the main advantage from such a provision. And then, of course, the basal option, which I will not now go in deeper, but you can read it in the article. But mainly the 3 options I just mentioned are still human rights. So from an anthropocentric tool, you use it to improve animal protection, but with really introducing animal rights in the Belgian constitution, you on a fundamental level, it's another approach. But at this stage, I think it's at least something we should not set merely aside, but as we've seen the referendum almost now 1 year ago in Switzerland, this will happen more and more. So instead of just not taking it to account, it would be better to take it into account in further discussions. So far, the first part of my PhD, here again, you can see a summary of the different options and their impact and so on. Now, the second part. And here we will delve deeper into the concept of animal rights, animal welfare rights, and so on. So before it was more the emphasis on animal welfare. Now here really is the purpose to use this idea of animal rights and make it more tangible. Now at the title is the European Animal Rights Revolution. As I mentioned before, Article 13 TFEU is excluded. So here you should understand the regional level as Europe, not the European Union and its 27 member states, but Europe with the Council of Europe, including many more countries than what is the case with the EU. What I did here was actually more of an intellectual thinking exercise to make the idea of philosophical animal rights make it a legal translation of what is mostly a philosophical discussion. Now I want to make it very, very concrete and use the European Convention on Human Rights to put their animal rights. Of course, I know there are a lot of red flags here using this human rights framework, and I also mentioned them in my PhD, but now it's really straightforward just to give you all an example, but there are a lot of nuances here which I will not go into depth. But of course, I know they exist and they are elaborated on, in my PhD. The title of the chapter is One Health, One Welfare, One Right, Introducing Animal Rights in Europe. So animal rights, well, it is an umbrella term. And again, I refer to the framework of Saskia Stuckey. And I really focus on legal animal rights. So not on the social movement, not on philosophical animal rights, but what how should we perceive animal rights? So at the one hand, we have the simple animal rights, as Saskia Stuckey explains, better known as the animal welfare rights. So most of the rights which are now included in domestic legislation and general animal welfare acts. On the other hand, we have fundamental animal rights, which are more or less in the format of human rights. So to speak of fundamental animal rights, you need to have both conditions fulfilled. And with simple animal rights, it's always only one condition that is fulfilled. To give an example, there are many more in Saskia Stuckey, her article, which I would recommend you all, if you have not yet read it, to read it, because it's very a framework to build on and so on. Now, the right to be on the right for unstunt or for stunt slaughter. So in Article 15 of the Belgium Animal Welfare Act, we have the right for vertebrates to be killed with prior stunning. So it has normative force, because on the same Animal Welfare Act, we have a criminal provision which sanctions this provision, that says that if you not apply with this provision. So it has normative force, but does it also has substance? So here you have the difference between a primary interest and a secondary interest. The right to be killed with prior stunning is still a right to be killed, even it's with prior stunning. So it's more a secondary interest compared to the primary interest to the right to life, for instance. So that is the two conditions that should be fulfilled. On the other hand, you can have, for instance, substance. You can have a right to life, but it's not enforced at all. If it's not criminally sanctioned, then again, both conditions are not fulfilled. Now, working with this concept, I tried to translate it or to transpose it in something we currently know as a legal instrument. That's why I also said that there were many disclaimers in the title. Is this new or not? At least it's a new approach. Is it an instrument? And so on. So I mainly distinguish two avenues. First of all, the Article 1, which more or less corresponds to the idea of fundamental animal rights, and then also Article 8, which corresponds to the simple animal welfare rights ID. First, I will drill down on Article 8. You might be familiar with Article 8 of the European Convention of Human Rights, yes or no, but it's the right on protection on family, home, correspondence, and so on. And it's also accepted that it includes the human right to a healthy environment. It's not expressly mentioned, but the case law accepts that it includes over there. Now, likewise, we can also argue for a human right to animal protection. Now, I will leave aside if it should be incorporated under this right to a healthy environment, or be it as an autonomous right besides a healthy environment. I will not go into that discussion, but the idea is that as we humans have the right that, for instance, we want that the government makes a culture policy, a policy on the environment. We can also want the government that they make a policy on animal protection. So that's how you should see this animal protection human right. Now, it also corresponds to the new developments, as in one health, one welfare, and so on, that it's all interconnected. It's a very anthropocentric view, but it might still be helpful for animal protection on the end. You have also Justin Marceau with his link theory, linking animal abuse with human violence and so on. Now, it's not mere anthropocentrism, it's responsible anthropocentrism. It's a term coined by Judge Pinto de Albuquerque in his partly concurring and partly dissenting opinion in Herman versus Germany. So what we do is we broaden our circle of morality to also include animals. So yes, it's anthropocentric, but it might be a springboard for future ecocentric viewpoints. Now, on the other hand, now it's more fundamentally, Article 1 of the European Convention is in fact the scope on who applies the rights. So we have the advantage in comparison with the Universal Declaration of Human Rights, which on several levels uses human also in its provision, that the purely concepts and terms used by the European Convention, they use everyone or one and so on, and not human as such. But of course, yeah, it's a small advantage. But on the other hand, we see in the preparation and that the European Convention in fact refers to the Universal Declaration. But what we could do is reinterpret everyone to also include some animals and so on. Of course, it's a discussion of which animals, which rights, and so on. You can read it all, in the article in full, but an example could be the criteria of practical autonomy, which is used by Stephen Wise in his book Drawing the Line, Science and the Case for Animal Rights. There are many criteria. You could also use saintism and so on, but it's just to show that it is possible. We have the tools, but of course it's not as it's a possibility that it's also something that society really will accept. Now, how can we establish this? Well, by a dynamic and evolutionary or revolutionary interpretation. In this human rights framework, human rights, according to the protest school, is seen. You have 4 schools of human rights, and one of them you also have the nature school, and so on, is the protest school, who sees that, who perceive human rights as a defending mechanism for defending marginalized groups. And in my opinion, animals perfectly fit in this group. Of course, I did not go in depth on all particularities, but you can read it in the articles. Now, what we see is that the advantage from one approach will also be the disadvantage of another approach. So you might criticize the idea of responsible anthropocentrism because it's still anthropocentric. But on the other hand, the idea of fundamental animal rights will then be criticized as a non-option because it will not be taken into account at all. So it's a difficult balance, and yeah, we will need to take one road or another. Now, finally, the third part is that of sustainable development and animal welfare, international partners in crime. So it's a mental game to switch first from animal welfare, animal rights, animal welfare, I know. But as I pointed out to you earlier, that in the introductory frame of reference, the state of the art, a major lacuna was that we don't have an international framework. And that's where I build on this part 3. How could we achieve such an international framework? And now here we actually zoom out, not look into the animal instrument, but also perhaps take a broader view at how to achieve this goal. So part 3 is subdivided in 2 chapters. Chapter 4, which can be summarized as the soft law trajectory, and chapter 5, more the hard law trajectory. Now I will move on a bit more quickly, so we have maybe still some time for a question. But chapter 4, to put it in a nutshell, it's identified that in soft law, for instance, in SDGs, animal welfare is not included. So we have 17 SDGs, but the Global Sustainable Development Report of 2009, which is a 4-annual report, and this year a new one will be published as well. They mention that animal welfare is a key issue, but it's currently missing from the Sustainable Development Agenda. So it's favorable that it's acknowledged that it's missing, but of course, problem is that it's missing. So that's a first fact, that the animal welfare is not covered yet. But you should know that, for instance, when there were petitions or to vote from what the 17th SDG should be, and animal welfare was the topic that received the second most votes. Also, we have a legal doctrine, an article that discusses that maybe animal welfare, animal health, and animal rights should be an 18th SDG, and so on. Now, why the SDGs? Because it's soft law, but it has a major influence on policy. On worldwide policy, think of the World Bank, but also major players like Coca-Cola also align their policy on the SDGs. Now, chapter 5 then makes this exercise to transpose how we should reconceptualize sustainable development in order to ensure that animal welfare would be incorporated in it. Well, you have 3 legal actors which play a role. Of course, first, legal doctrine, who need to substantiate this new concept. We can also look into other fields as well. For instance, you have Broom, a renowned veterinary scientist, which already uses, in his definition of sustainable use, he makes reference to morality of action, in which animal welfare can be included. Once this concept is substantiated, the legislator can use it to make as anchor point for further legislation. And of course, we have the court, the judges, who can use it again as a heuristic, as a reinterpretation technique. Think of the WTO shrimp case, where also sustainable development was used to interpret some concept of the WTO agreement. So that's the idea to mitigate the gap at an international level. So what I did not talk, which I not yet talked about, is the mutual benefits, but there is the idea of including animal welfare in sustainable development is not only beneficial for animal welfare, but also for sustainable development itself. There is a Swedish study that examined that if animal welfare would be included in the SDGs, not only it would be beneficial for animal welfare, but also the SDGs would be more efficiently be accomplished. Also, with sustainable development, you have the gap that you have by animal welfare is totally different than with sustainable development. On the international level, you have many, many conventions regarding sustainable development. So it would help to have also animal welfare on the international agenda as well. And to end the backing of the United Nations. So what this part 3 of the PhD did was to make the idea tangible that we need to connect animal welfare with sustainable development. And that also resulted, or is the same idea we see in this recent resolution of March 2022, where for the first time this connection is made. It's a real milestone. It's still soft law, no hard law yet, but it might be a first step. Now animal welfare is put on the international agenda. We have UN support, which was all these years lacking. So we see improvements over there. So this brings us to my conclusion. So here again, the more comprehensive overview, what I told. What I want to say is that there are many, many roads and many pathways to take to improve animal welfare or animal rights. You can do it on an international level, you can do it on the national level, you can do it both, because I can see that when many national countries will include animals in their constitution, it will also be more easy to have an international treaty. And also the top-down approach, once we have a UN consensus, also the member states will also apply it. So in fact, there are many solutions there. And then will great primates ever run the world? Well, that's the question, but as a situation today, probably not. And another title for this work is Devolved Parliament, but maybe I think a better title would be Evolved Parliament. And last but not least, our credo of our university is Dare to Think. And that's what I try to do, but I hope now the policy makers will dare to do. Thank you.